Refugee Commission, and Lizeth Martinez from the Centro de Derechos Humanos del Migrante in Ciudad Juárez. Each of our organizations has extensive experience working with and advocating for the protection of those apprehended and repatriated at the United States-Mexico border. On behalf of the petitioners, I'd like to once again thank the Commission for granting our request for a thematic hearing dedicated to the pressing issue of human rights violations by Customs and Border Protection. As the Commission is aware, over the past 6 years, No More Deaths has interviewed nearly 15,000 victims of Border Patrol abuse. What has emerged is a clear picture of a detention system that either cannot prevent or to some extent condones the mistreatment of those in its custody. Our most recent report, A Culture of Cruelty, included the following findings. 11,384 reports of inadequate access to food, higher rates of denial of water among children than adults, 374 cases of individuals being repatriated without needed emergency medical care or medication, coercion into signing legal documents, unsanitary and inhumane processing center conditions, and reports of verbal, physical, and psychological abuse. I'd like to share one representative case that was documented by the Women's Commission. A 17-year-old girl who fled Honduras after being raped and impregnated by an abusive boyfriend was apprehended by CBP. When she told them that she was 7 months pregnant. They kept her in a short-term hold facility without adequate food despite her pregnancy. She asked for a lawyer and informed CBP that she was terrified of returning to Honduras. Instead of referring her for a credible fear interview as required by United States law, the officers accused her of lying and told her that she had no right to legal assistance because she was undocumented. The Border Patrol also routinely employs a number of dangerous repatriation practices that exacerbate detention abuses and needlessly put immigrants in danger. Nearly 3,000 individuals reported that their personal belongings were not returned to them prior to repatriation, including money, medication, cellular phones, and identification. About 900 family members reported being separated during detention and deportation and being denied information about relatives' whereabouts. Family separation frequently involved lateral repatriation or deportation through ports of entry that are distant from the location of apprehension. Some of the dangerous and abusive practices that we've described appear to violate existing repatriation agreements between the United States and Mexican governments. Others, asylum and trafficking screening requirements set forth in domestic and international law, including the TVPRA, the Trafficking Victims Protection and Reauthorization Act of 2008, the American Declaration on the Rights and Duties of Man, and the United States Convention Against Torture, the United Nations Convention Against Torture. For years, No More Deaths and other advocates have engaged available venues to raise these concerns with Customs and Border Protection. However, rather than substantive dialogue, the agency has taken the position that such abuses simply do not occur. It has refused to release complete versions of existing detention policies or to allow civil society organizations access to the facilities to monitor conditions. Efforts to use these existing oversight mechanisms have been similarly unproductive, in part due to the fact that all are internal to the Department of Homeland Security. Recently, several encouraging developments have occurred. Customs and Border Protection has now established a permanent NGO liaison position at the headquarters level. As of this past Friday, CBP has agreed to an advocate tour of short-term detention facilities at the end of May. And after nearly 7 months of waiting, local Border Patrol leadership is expected to meet with No More Deaths to discuss our report next week in Arizona. And this month, the Office of the Inspector General contacted No More Deaths as part of an investigation into a complaint that we filed last year. While encouraging, we are not yet convinced that these developments indicate any meaningful change in posture. During congressional testimony last month, Homeland Security Secretary Napolitano clearly gave the impression that the issue of Border Patrol misconduct is not a priority of hers. Such a public stance from the Department of Homeland Security leadership is of grave concern to us.
Our first-hand experiences have made us experts in what is terribly wrong about Customs and Border Protection's detention and repatriation practices. As a result, we have been able to identify some of the initial steps required to ensure that the Border Patrol begin to respect the human rights and dignity of those in their custody. We ask that the U.S. government establish an independent oversight mechanism to monitor Customs and Border Protection with adequate staff, resources, and authority to investigate complaints and hold parties responsible when appropriate. Any governmental, non-governmental, or contracted oversight mechanism should be able to respond to a full range of complaints and make enforceable recommendations. We would encourage this oversight body to view complaints along the full spectrum of severity as being worthy of attention. For example, that the routine failure to return personal property would be viewed as seriously as complaints about physical or psychological abuse. If CBP is already participating with oversight bodies on a regular basis, that involvement should be made public. Findings should be made available, as well as any recommendations and outcomes of those recommendations. We ask that the government establish regular civil society access to Customs and Border Protection short-term detention facilities, consistent with current policies for civil society access to Immigration and Customs Enforcement detention facilities. We recommend that an independent oversight mechanism be accompanied by opportunities for civil society to monitor Customs and Border Protection detention centers. Such access increases opportunities for dialogue regarding policymaking, increases confidence in the government's ability and willingness to respect human rights, and gives advocates additional ways to gather information about detainees' treatment while in custody. Such monitoring is especially important for Border Patrol detainees who have no access to counsel while in short-term custody. We encourage Customs and Border Protection to consider the ICE access policy and other similar policies to develop a model that would be most appropriate to the CBP context. While there are variations from agency to agency, the outcome should be the same: increased access and transparency. We ask for the end to lateral repatriation and any other enforcement initiative that separates families during detention and repatriation. Any form of repatriation that routinely separates people from their families or traveling companions is an abusive practice. We are particularly concerned about the increased use of lateral repatriation as a result of criminal prosecution programs, which often results in people being detained all over the country and deported at ports of entry thousands of miles from where they entered. Similarly, the increased use of internal repatriation programs is concerning insofar as the policies around the use of these programs are not transparent and they are not carried out in a way that provides human rights observers access to documenting the conditions of people in detention, transport, and upon their repatriation. The entities that respond to people once deported need to be given timely and sufficient information in order to help locate family members from whom they have been separated, including information about which port of entry they have been sent to. This would require speedier and more efficient data sharing with the Mexican consulate. We ask that the government improve existing complaint processes to increase accessibility and responsiveness. Current complaint processes are difficult to navigate and lack transparency, providing little to no information regarding allegations of abuse. They have limited ability to change the Border Patrol's systemically abusive practices and do not demonstrate a sincere commitment to investigating complaints they receive. If there are existing local and centralized complaint processes already in place, they should be broadly publicized so detainees and advocates know how to access them. The forms should be available in multiple formats and in multiple languages in order to improve accessibility. The instructions for submitting them should be made clear. Customs and Border Protection should not rely on other bodies, such as the Office of Civil Rights and Civil Liberties, to manage complaints for them. CBP should create and publicize a complaint reporting structure that makes sense for the specific nature of the agency and which is able to respond to all types of complaints, not only egregious ones. Localized complaint processes should be streamlined in a way that combines data about types of complaints and their outcomes with the same information across sectors and regions. Aggregate data gathered from complaints should be made public so as to provide oversight bodies and the general public an idea of what issues should be the area of focus during routine monitoring. And finally, we ask that the government respond to information requests already pending with Customs and Border Protection, including the full unredacted hold rooms memoranda, policy regarding enforcement in sensitive community locations, the definition of family currently applied by Customs and Border Protection to detention and deportation, and any policies which apply to mixed immigration status families or those separated due to detention or deportation. Many of these information requests are long-standing. It is impossible for advocates to meaningfully contribute to improving practices they have little information about, and the agency's lack of responsiveness communicates a posture that is hostile to civil society and transparency. In addition, we request that the Commission conduct an independent investigation of the human rights situation for migrants detained and deported at the United States southwest border, with special attention to the United States Border Patrol's treatment of migrants during apprehension, detention, and repatriation. We found the Commission's in-depth analysis of the United States immigration detention system to be an asset to ensuring that the United States is in compliance with our international obligations. We believe it would be helpful for this issue as well. A study would be most effective if it were to include tours of short-term detention facilities with the ability to interview current detainees, with Border Patrol agents and leadership working in various sectors, access to all regulatory material and records, interviews with recently repatriated detainees, and monitoring of complaints filed through current oversight mechanisms. Today's hearing comes at a critical juncture. While there is no doubt that reforms are urgently needed, it remains to be seen if Customs and Border Protection, the Department of Homeland Security, and the federal government will take responsibility for its role in ensuring that such changes occur. We are hopeful that the opportunity to bring this important issue to the attention of the international human rights community will encourage the United States to adopt policies that better reflect the values it espouses. Thank you.
Thank you very much. In my haste to begin, I neglected to introduce my fellow commissioners. Commissioner Felipe Gonzalez, who is the country rapporteur for Mexico, as well as the thematic rapporteur for migrant workers, and the second vice president. My apologies. Commissioner Escobar Gil is the country rapporteur for Mexico and also for persons deprived of liberty, and are very important participants in this discussion. I am going to give the state an opportunity to respond to some of the very specific concerns and questions.
Thank you very much, Commissioner, and distinguished commissioners, distinguished petitioners, and to all the non-governmental organizations that have requested this thematic hearing. Ladies and gentlemen, we appreciate the opportunity to appear before you today and have assembled our top experts to address the topic at hand. Let me introduce our experts. From the Department of State's Legal Advisor's Office, Mr. David Sullivan. From the Department of Homeland Security, Ms. Tamara Kessler, Director of the Office of Civil Rights and Civil Liberties, and Mr. Ron Vitiello, Department of Homeland Security, U.S. Border Patrol Deputy Chief. I would like to say that our level of interest and representation underscores our commitment to support and engage seriously on this topic with the Commission. Let me ask Ms. Kessler to continue. Oh, I'm sorry. Mr. Sullivan will speak first. Thank you.
Thank you very much, Mr. McGlynn. And thank you, commissioners and members of civil society. I'm going to be very brief, so it's understandable that he would have introduced Ms. Kessler. Distinguished commissioners, Office of the Legal Advisor at the State Department joins our mission to the OAS in expressing our deepest respect for the Commission, and we strongly support the important work that the Commission does to advance the promotion and protection of human rights throughout this hemisphere, including in the United States. We firmly agree that the United States has an obligation to ensure the human rights of all migrants, documented and undocumented alike. This recognition is grounded in the U.S. Constitution and other applicable domestic law, as well as our international obligations and commitments to human rights. We are here today because of our political commitment to uphold the American Declaration of the Rights and Duties of Man, which, although a non-binding instrument that does not itself create legal obligations on signatory states, is a very important guide in the field of human rights. At this thematic hearing on the important issue of the human rights of immigrants at the U.S.-Mexico border, the United States is proud to have senior-level representation from the relevant agencies. I would now like to introduce Tamara Kessler, Acting Officer for Civil Rights and Civil Liberties at the Department of Homeland Security. Thanks.
Thank you. Thank you so much. I'm very pleased to be able to address the Commission today. I'm going to focus on what our office does, the Office for Civil Rights and Civil Liberties at DHS, which we call CRCL, and in particular the complaint process and our work along the southern border. It's the statutory mission of CRCL to support DHS as it secures the nation while preserving individual liberty, fairness, and equality under law. CRCL integrates civil rights and civil liberties into all of the department's activities. Our office is a policy office. We do not have criminal jurisdiction, we do not have law enforcement authority, and we do not have disciplinary authority. We work with DHS components and offices to address concerns raised through our complaint process and through our communications with the public, which are many, and through our more proactive review of DHS policies. The CRCL complaint process is generally our complaints come from the public, and we review and assess our complaints that allege violations of all different kinds of human rights, civil liberties, and civil rights violations related to DHS programs. Specifically, some of the examples would be physical abuse, discrimination based on race and ethnicity, national origin, religion, gender, sexual orientation, or disability, inappropriate conditions of confinement, and infringements of free speech. CRCL receives complaints from a variety of sources, including NGOs, the public, other offices at DHS, and other government agencies. Under our regs, the Office of Inspector General has the right of first refusal on all cases. What they don't take, and if they decline, it comes back to CRCL to investigate. At that point, CRCL makes a determination based on our discretion of whether we will keep the case because it requires that kind of expertise, and we will do our own investigation. If we determine that the case can be investigated by the component like CBP, we will refer it back to their experts in their internal affairs division and have them do the fact-finding. The case then comes back to us, and we review it very, very carefully and determine we don't always agree with the determination by the component, and we at times can make a decision that would differ, or we can make recommendations coming out of that fact-finding. In 2010, we've generally been moving away from referring cases back to the components, and in 2010, we actually only referred out 32% of our cases. The rest we kept. We've also instituted a new policy in 2010 where DHS components are asked to formally concur or non-concur with our recommendations and to provide concrete action plans for implementing accepted recommendations. The petitioner has alleged that we have a lack of independence because of our complaint process. I disagree. I think CRCL actually guides and monitors the course of the component investigations by guiding them with questions and specific requests for information. And as I said, when we get it back, we're extremely careful. We do a full file review, and we don't often, we could disagree with what the component has found. We have excellent staff who are dedicated civil rights people, and they're very, very careful about making sure that the component has done their job. Although we believe that the referral process is efficient and it definitely helps with our limited resources, CRCL has relied less and less on this in recent years. And as I said, we only had 32% of complaints opened in 2011 referred out for component investigation. Really, CBP, we've had a number of recent complaints, and we've come up with some great recommendations, which I think overlap with a lot of the petitioners' concerns. For instance, a Border Patrol station now ensures that males are not placed in hold rooms occupied by females and that the hold room designated for females is properly marked. In addition, CBP detainee meal policy has been revised at border stations to ensure that persons who arrive between fixed meal times receive food with reasonable frequency. A port of entry has reiterated proper shackling technique to its officers and reminded them that the purpose of restraints is not to punish but to enhance safety for officers and subjects. And a port of entry has established a clear policy on appropriate use of detention cells instead of leg restraints. In addition to our work on the complaints process, we also proactively work on different issues along the border, and one example of that is the Unaccompanied Alien Children Working Group, which is being run at the very top level of the department by the Office of the Secretary. Finally, I'd like to specifically address the correspondence received by CRCL from the petitioner. Since 2010, we've received a number of letters from the petitioner. In the first half of 2010, we received a series of 3 submissions with a combined total of 74 individually documented allegations. Many of the allegations were anonymous, and even when the allegations included some identifying information, the information was generally insufficient to serve as the basis for a thorough investigation. We were closely in touch with the petitioners about this issue and informed them that while anonymous complaints could be submitted, insufficient information would significantly impede CRCL's ability to investigate. Despite the lack of information, CRCL and CBP spent weeks reviewing internal documentation in an attempt to identify complainants at the border station where they were processed. As part of this effort, CRCL had numerous email exchanges, phone calls, and in-person meetings with the petitioner. In these meetings and correspondence, CRCL has reiterated the importance of providing as much information as possible to enable an investigation into complaints submitted. CRCL also informed the petitioner that even where the information submitted was insufficient to conduct a full investigation, the information would be entered into our database so that we could identify potential trends or problematic border stations. CRCL has opened 15 separate complaints based on correspondence from the petitioner. We have notified the petitioner in writing of which 15 we were able to investigate. Of these 15, 8 remain open and under investigation. In cases where CRCL determined that the correspondence contained insufficient information, CRCL notified the petitioner of that decision. In cases where we completed the investigation, we notified the petitioner that we had closed the case, but we were unable to provide any additional information because the petitioner had not obtained a privacy waiver from the complainant, allowing CRCL to provide that information. Thank you for your attention, and I would be happy to answer any questions.
Good morning. I'd like to thank the Commission for an opportunity to speak before you today and for the important work that you are involved in. As America's frontline border agency, Customs and Border Protection's priority mission is to protect the American public while facilitating lawful trade and travel. CBP is responsible for protecting more than 5,000 miles of border with Canada, 1,900 miles of border with Mexico, and over 95,000 miles of shoreline. To do this, CBP has deployed a multi-layered risk-based approach to enhance security of our borders while facilitating the flow of lawful people and goods entering the United States. The U.S. Border Patrol has a proud history of nearly 88 years of service to the nation. Although enormous changes have affected nearly every aspect of our operations from the earliest days, the basic values that helped shape the patrol in the early years, professionalism, honor, and integrity, respect for human life, and a shared effort have remained. The area between the ports of entry consists of miles of open space, desert, waterways, forests, and prairies, making our nation's borders vulnerable to threats of terrorism and to exploitation by smugglers and illicit contraband. It is in these areas that you will find Border Patrol agents patrolling the border for illegal activity, preventing and interdicting smugglers, narcotics, and other contraband from entering the United States, and frequently rescuing those in distress. Border Patrol operations are conducted throughout the year in the harshest of conditions in the most remote areas. Rescues take place in environments varying from the bitter cold and precipitation of mountainous terrain to the blistering heat of the low desert. In 1998, the Border Patrol Search, Trauma, and Rescue Team, BORSTAR, was created in response to the growing number of migrant deaths along the border. BORSTAR is comprised of well over 200 agents who volunteer to go beyond the regular line watch duties. They attend physically and mentally demanding, rigorous academy to learn various techniques and skills, including search and rescue, tactical medicine, technical rescue, and land navigation. All BORSTAR agents are certified emergency medical technicians, and many are paramedics. BORSTAR is often the only rescue entity available for miles along the inhospitable border region. We also use track and trail canine teams to locate missing and distressed persons. Border Patrol arrestees and detainees are treated humanely while in custody. Upon arrest, they are taken to Border Patrol stations where they are processed. Their biographic and biometric information is captured. Record checks are run, and the resultant of all the available information, that individual, a determination for disposition is made. Every effort is made to promptly process, transport, remove, or release those in custody in accordance with Border Patrol procedure. While in custody, well-established practices are in place to ensure that anyone detained will be held in a facility that is safe, secure, clean, and while being provided access to water with provided food. Medical services often provided when needed. In all hold room, females and males are separated from males, and juveniles are separated from unrelated adults. Unaccompanied alien children are a unique population and are detained and transferred according to the Flores Settlement Agreement, the Homeland Security Act of 2002, and the Trafficking Victims Protection Reauthorization Act of 2008, TVPRA. All agents are required to complete human trafficking awareness and unaccompanied alien children training annually. The course emphasizes the impact and characteristics of human trafficking, provisions of the TVPRA and the Flores Settlement Agreement, and requirements for the care and treatment of minors. The Border Patrol has a dedicated staff at headquarters and at every sector to ensure that the rights of unaccompanied alien children and vulnerable populations in custody are protected. Furthermore, Border Patrol sectors and stations maintain qualified and professional staff of EMTs and search and trauma rescue cadre to quickly attend to any persons who might be in distress, whether in the station or at the field. We also comply with all aspects of the Border Patrol hold room and short-term custody policies that details all requisite accommodations for persons in custody. The Border Patrol is fortunate to have a dedicated cadre of agents. Our agents are routinely lauded for their contribution to the communities in which they work and reside. This is also characteristic of the agents working along the international boundary and in processing centers. It is the norm to hear about situations where an agent has executed a rescue disregarding their own safety. Being an effective Border Patrol agent requires compassion, and one often encounters individuals with less than flattering circumstance. I'm proud of the agents for their citizenry and professionalism that they emulate on a daily basis. CBP policy serves to ensure that action taken by agents while in the performance of their duties are conducted professionally and within the scope of their authority. The agency places high importance on affecting the appropriate detention and treatment and the needs of detainees while taking into account operational parameters and safety. Abuse is not something we promote or tolerate. If it happens and we are made aware of it, it is reported, and often by the agents who witnessed the misconduct. All complaints and allegations are reported to supervisory agents. They, in turn, ensure the appropriate actions and notifications are completed. Complaints and allegations are expeditiously forwarded through the chain of command as well as to the CBP Joint Intake Center for further investigation and resolution. A culture of cruelty is not a true reflection of the U.S. Border Patrol that I know, and an organization of men and women in uniform who will protect our nation's sovereign borders. I welcome the opportunity to answer your questions at this time.
Thank you very much. I'm going to defer to Commissioner Felipe Gonzalez to begin the questions. Thank you to both the petitioners and the state.
Thank you very much, Madam President. As a rapporteur on migrants at the Commission, I would like to thank both the petitioners of this hearing and the delegation from the state for the information provided to the Commission. I think this is a very good opportunity to continue the follow-up that the Commission, as usual, is conducting about a report published, in this case the report that the last year Commission issued on the condition on detention and access to justice and due process of migrants in the United States. We already held a public hearing on this matter last year, and later we had a working meeting with the government, and now we can address some of the problems that were covered at that report. One of the issues that has been stressed by petitioners here is the issue of their participation, and the role of the civil society in monitoring the condition of migrants in southern United States. According to the information presented by the petitioners, they have not had full access to the policies of the that guides Customs and Border Protection, short-term detention procedures and practices. It says that they got this policy in a highly redacted form. I would like to have the petitioners to elaborate more on this matter, and also to hear the version from the state in this regard. For the Inter-American Commission, as a general matter, it's very important that civil society have the means to monitor, to adequately monitor human rights conditions, in this case the situation of migrants. In the case of migrants in particular, because they are usually don't have enough meaning to defend themselves, or they have, in the case of undocumented workers, very restrictive means to be able to reach a court, or more generally speaking, the state to present a complaint. It is very important that civil society, as such, the organizations, the NGOs, are allowed to conduct full investigations and get all the information to have a strong participation in this regard. I have heard two versions here about the role being played by the Department of Homeland Security Office on Civil Rights and Civil Liberties. On the one hand, the petitioners have provided information in the request for the hearing that they have filed over 75 complaints since late 2009, and that no identifiable outcome has been achieved in a single case. I heard from the delegation from the government that they don't share the views of the petitioners concerning the role being played by the CRCL, but I would like a more specific response on the part of the government about the number of complaints that have been filed and where there is any specific outcome regarding some of them. And finally, I would like to, two more questions. One, for the petitioners, I would like to hear about more specific ways that could enhance their participation regarding the condition of migrants in southern United States, especially the issue that it's here, the detention and repatriation in that region of the U.S. And I would also like both parties to address the issue of an independent oversight mechanism. I would like the petitioners to be more specific on how why, according to them, the CRCL doesn't play that role, and how an oversight mechanism should be designed in order to be fully effective. And from the government, I would like to hear if there are any ideas to enhance the mechanisms that already exist. Thanks.
Thank you very much, Commissioner Gonzalez. A few additional questions from me. I'm interested in finding out, to follow up on Commissioner Gonzalez's question to the state, the time frame for resolving complaints, and there may be a range, particularly given the concerns of the petitioner that many of the complaints they've been involved in haven't been resolved. I'm also, like Commissioner Gonzalez, interested in access to the question of access to information about the policies and the principles being applied, and how available this is, and if some of that information isn't being made available, what might the state's concerns be. And then I also, in response to to the state's discussion around the Customs and Border Patrol activities, I noticed that there, internally, there was a mechanism through which officers or persons who were employees could forward on complaints through the system based on your presentation. And I wondered how often that was used, whether there was that a meaningful way of addressing some of the concerns? In other words, was there an incentive or meaningful use by employees of that particular complaint mechanism? And then alternatively, access of persons detained to meaningful knowledge of the existing processes, whether that is provided by the state. Thank you very much. I'm going to allow the petitioners first to respond to some of the questions, perhaps about 5 minutes to begin, and then the state.
Thank you. So we'll try to provide as much information as we can as quickly as possible and hopefully submit additional responses in writing. In terms of the information we had about the hold room policies, the initial request through the Freedom of Information Act happened about 4 years ago, and the first response, which took over a year to get, was entirely redacted. We didn't even print it because the pages were literally all black. And about a year later, we got a less redacted version, but I'll give you an example of the kind of information we still lack. For example, there's a section that describes the definition of a family, and the version of the hold room policy we have says the definition of a family is, and then that section is redacted. And that's a problem for us for obvious reasons, because when we encounter people post-deportation that describe a situation that describes like that sounds like the kind of situation about which we would make a complaint because it seems to contradict what we would assume good CBP policy is, it's difficult for us to do that because we don't actually know what the policy is. We presume that deporting a child without their parent is against policy, but because we don't have the full policy, it makes it impossible for us to provide meaningful feedback back to the agency about shortcomings in policy and practice. And I think that both my colleagues will also respond to some of the other questions that the commissioners raised, but on some of the questions about the complaint process, we have concerns about what we consider an impossible position for CRCL, in the sense that they're not given the mandate to be able to investigate, and they don't have disciplinary authority. So the mechanisms that do exist are internal to CBP. Very little information comes out publicly about the results of their work, and it makes it very difficult for us, when we continue to see the same patterns post-deportation, to have confidence that those mechanisms are meaningful ones for holding agents accountable for their behavior. And I think that we can talk a little bit about how that works specifically with CRCL. But for example, CBP very recently made improvements to its complaint process, which until very recently did not exist. There wasn't a form. It was very difficult to know how to file a complaint if you wanted to file directly to CBP. And now all the information is entirely online. It's in English. It's not accessible to people who are the kinds of people who would file complaints on their own behalf. And that's just one example of how there are structural shortcomings that preclude complaints being filed, which gives the agency a very limited sense of the kinds of concerns people have with their agents' practices.
One of the issues that we've had with the existing complaint process is that one thing to directly respond to one of the concerns raised is that we don't ask necessarily for the full outcome, including personnel decisions or anything of that nature, but we haven't been given access to a general sense of data of these 75 complaints or 74 complaints. 8 resulted in found claims or however many. And one of the things that we suggest is a general report out, made public, of what types of complaints are being filed by us and other agencies. Because, we know that we're not the only petitioners who file complaints and use that existing process. So what kind of data is being submitted to CRCL, and what are some of the outcomes in a general data sense that we can use to identify what issues we should be advocating for, which ones are already being addressed, and which ones are already being worked on internally through CBP. And similarly, I know that we have expressed concerns about the fact that CRCL exists within DHS, within the Department of Homeland Security. And on the ground, when working with people who have recently been deported, who are either leaving ICE facilities or Border Patrol facilities, or a combination of both somewhere along the line, we have had a difficult time in encouraging people to really submit all of their identifying information in order for a full investigation to be conducted, because they know that the investigation will likely be conducted by ICE or by Border Patrol agents, and that is a very intimidating position for someone who is expressing concern about their treatment while in one of those facilities, to then know that their information and perhaps their family's information is going to be submitted to the same agency that they're reporting misconduct about. So we have submitted anonymous complaints so that the data is in, but the fact that that is the process that's available to us has been very difficult in helping people feel empowered enough to make reports against the agencies that they feel abused by.
If I may just briefly answer Commissioner Gonzalez's last question about specific ways in which civil society could engage with the government. I think we mentioned being able to monitor facilities like civil society has been able to with Immigration and Customs Enforcement facilities. Would be extremely helpful for us to get a clearer picture of what problems are happening and what problems are not happening, because right now we're only hearing problems and complaints that are coming out of the facilities, and we're not able to see for ourselves and feel assured that the government is complying with international human rights standards. Secondly, being able to see the policies, again, to be able to compare, is the United States government meeting its own policies, and are those policies appropriate, and do they meet standards? Finally, we would like to have civil society be able to engage in some of the working groups that the government talked about. For example, this new working group on unaccompanied immigrant children. Numerous times different agencies have asked to, different organizations have tried to work with this working group. So it would be great if it could be a civil society and governmental working group to have the expertise. And finally, as to your question about independent oversight, I think we have lots of ideas of how that could happen and how the current system could be improved, and we will submit that in writing after this hearing today. Thank you.
Can I give the State an opportunity to respond?
I'm happy to answer the questions about CRCL. Just to answer Commissioner Gonzalez's question about the 75 complaints. There were 75 complaints filed. There are actually forms filled out, handwritten forms taking statements from people as they're being repatriated across the border. And some of them have information about an actual incident and use of force, a name, a place, a date. Some of them are very sketchy in terms of an unknown person might have heard someone screaming. I mean, that little information. So we worked with those numbers. We opened 15 cases, and we sent notice to the petitioner that we opened those 15 cases. We've closed 7. We've sent notice to the petitioner that we closed those 7. We have 8 still open, and there are likely to be recommendations coming out of those. So, I mean, I think we actually went above and beyond in terms of trying to track down information from these handwritten notes, and that we were quite successful in the end in being able to open any of them, actually. In terms of transparency, we put out an annual report which doesn't contain any personally identifiable information, but it does contain the summaries of the cases that we've completed in which there have been recommendations. And so that's available online. We actually do quarterly statistics, which are broken down by the area of complaint, for example, excessive force, conditions of detention, profiling, and talk about the different components of DHS which would have handled those cases, whether we handled the case ourselves within CRCL or whether it was referred, and then or what we have a new short form to try and deal with, because we actually got almost 300 new complaints last year. So we have cases which we handle in a more rapid way rather than a longer process. In terms of our process, we revamped it significantly last year, a year before last actually now, and we had an amazing amount of input by NGOs into how we did that, including the complaint form and the instructions. They're online, they're available. We have them translated into at least 12 languages. We have a language line available for people to call. And so I think we really did try to incorporate the views of the NGOs into our process, and I think we did a good job of that.
I would just add on the issue of the whole room policy and the redactions. The redactions are designed to protect law enforcement information, and I know it seems counterintuitive that we wouldn't be able to design or to develop the definition in public of family, but the idea here is that if that information is into the smuggling network and infrastructure, that people would use that like as a gaming tactic to relieve themselves of the responsibility of being detained or further prosecuted for smuggling ventures. And you all know, based on your work, that children are often exploited in that scenario, and so that's the justification. And then the anchors that legally allow us to redact that are all based on the need to protect law enforcement sensitive information. With regard to access, I think the May appointment for the tour is a step in the right direction. There is a lot of shared concern about recognizing that what we do needs to be in a transparent fashion. Our common interest to protect the livelihood and the dignity of the people who are in custody is equal, and so the more that we're able to open and solidify the dialogue and the relationship, I think is beneficial for both sides. He asked about self-reporting or agents who recognize misconduct and then report it through the system. We see CRCL and the Office of Inspector General within DHS, our own internal affairs units, as independent agencies. Their responsibility is to watch the work that we do and recognize, and when it's not in policy, to point that out to us. It's often the case that in all of those formats that the workforce recognizes when policy isn't followed. And when misconduct occurs amongst the workforce, and they're often the ones that bring it to our attention. Roughly 3/4 of the internal cases that CBP has on the books are reported by employees.
I'm just curious whether that data is available as well as the other complaints.
Yeah, I would have to work with the Office of Internal Affairs to see what they have readily available, and we would be happy to share what is.
Thank you very much. I have a few more minutes. I could, if the petitioners wished to add a few more observations, give you 2 or so minutes, if you wish.
I think that there's one point that we were hoping to have 2 or 3 minutes for, so thank you. I think that we would agree that the CRCL model is one that is a model for the rest of the agency for how to engage with civil society and how to meaningfully incorporate feedback. I think we also participated in conference calls with the office explaining how to file complaints when there were adjustments being made to the instructions, supplied our own feedback, and I think that our feedback about the shortcomings of the complaint process, by and large, refer to the CBP element of complaints. So I think that we just want to reiterate that we have been able to have fruitful dialogue with CRCL about the limitations on our end and the limitations on their end in terms of the information we can have and what they can do with it, and the extent to which it can contribute to better policy making. And we're hopeful that we can see those sorts of strides on a really practical, functional level with CBP, because right now we get conflicting information about how information that is received at the local level versus the headquarters level, if that goes to headquarters, if that informs policy. We have a lot of questions, and so we're hopeful that we will have some clarity and be able to use that as a tool to the extent that we've been able to use the CRCL process.
And we have been in recent dialogue with the local Tucson sector of Border Patrol in determining what are the steps that need to be taken when a complaint is filed locally. But we hope to figure out a way to centralize those complaints and look at what other groups are seeing along the border in other sectors, and how we can centralize a complaint process so that no data is being missed.
So I think that we appreciate the strides that have been made and just want to reiterate that from the perspective of the people that we work with, current mechanisms do not appear adequately independent to really have their full confidence, and we look forward to working together to address that.
Any additional observation or comment? No? If not, then I wish to offer my thanks both to the petitioners and to the state. It sounds as if there is some progress being made. It does appear there's some additional issues which you still want to continue working on. And we've heard from the state a commitment to providing some additional information and to continue in that important dialogue with civil society. Thank you to you both.